Hello everyone and welcome to our panel today, which is Beyond the Encryption Debate, a children's rights perspective on online child sexual abuse investigations. We're going to keep this as informal as possible. We put up 4 key areas that we'd like to cover in this session, and hopefully we'll have some time at the end for questions from the audience, so we'll try to keep to that. And just to start informally, I'm going to get everyone to just briefly introduce themselves so you know who they are.
Hi everyone, my name is Karen Garland. I am Head of Policy with the Mary Collins Foundation. We're a UK charity focused on the recovery of victims from technology-assisted child sexual abuse. I'm a lawyer by profession, and I've been working in the sort of area of child sexual abuse for many years and really care about child rights.
Hi, I'm Tamara Poliner, and I'm CEO of Heretical AI. We build tools to help with analytics in coercive and controlling crimes, such as domestic abuse or child sexual abuse. And I'm a computer scientist by background, and I work in natural language processing mostly.
My name is Achi Even. I am a child rights activist. I work for Missing Children Europe, and I have for the past 15 to 20 years worked in the EU policy field, working on policies for families and children, and most recently missing children. We've recently done some work on grooming and missing, and that's how we got involved in everything around child sexual abuse online. So that's our work. And we run a network of hotlines for missing children, the 116000 network that works together with law enforcement on all of these issues.
Hello everyone, I'm Desara Dushi. I have a mixed background in criminal law, human rights and technology, and I've been working in the area of child sexual abuse for over a decade, mainly in research but also in policy and governmental positions. I have a double PhD degree from University of Bologna and University of Luxembourg in law and technology, and my PhD thesis was on the live streaming of sexual abuse of children on the internet.
Thank you. And I'm Orla Drummond. I am a research manager and human rights lawyer with Trilateral Research. And I am the project coordinator of SALVUS. And SALVUS is a Horizon Europe funded project. It's a 3-year project. We're 1 year in, so we have another 2 years to go. And what we're looking to do is ensure safer justice outcomes in child sexual abuse investigations. So that's online and undercover. And we have 5 key areas in the project that we're looking to cover. So we have, the first is looking at the harmonisation of law in this area. So as we heard in one of the sessions earlier, the Commission are very keen on cross-jurisdictional sharing of evidence, but the law of evidence is different in each member state. So evidence that is collected in one country may not be admissible in another. So what we want to look at is the harmonisation of evidence collected to ensure that it can be used in these cases. We're also scoping practice in the field, so we're engaging with law enforcement and also with forensic teams that work on these type of cases to look at their practice in ensuring that they don't impact on fundamental human rights and that they also are very child-centred and victim-centred in their approach. We're looking to develop best practice guidance, and following that, we develop training materials for law enforcement and for forensic teams working on child sexual abuse investigations. We're also doing horizon scanning in terms of the technologies that's used by perpetrators, and that's been done by Aston University. So that kind of covers SALVUS and what we're doing. So before we get into the 4 key questions that were posted online, I'm going to ask Desara to set the scene and speak about the current regulatory frameworks on child sexual abuse investigations.
Yes, thank you. The regulatory framework governing the online child sexual abuse investigators is not that easy to navigate because it's a multi-layered approach, which goes from criminal law to data protection and fundamental rights and to platform obligations. And there is no instrument covering all of these layers. So there's a need of reading all of them together in order to be able to understand the environment. So starting at international level, we have the UN Convention on the Rights of the Child, which is it's the normative foundation in this area, and together with its optional protocol on sale of children, child prostitution, and child pornography. They have binding obligations towards state parties to protect children from all forms of sexual abuse and sexual exploitation, which means also online. It is a universally ratified law, except the US, who haven't ratified it. One of the fundamental principles of this convention is the best interests of the child, which all actors involved should have should take into consideration, to primary consideration. Then the optional protocol goes more into detail, regulating or ensuring that each state party criminalizes the production, distribution, and possession of child sexual abuse into their national criminal laws, and also in assisting each other into investigations, extraditions, and evidence gathering. We also have the general comment number 25, who acknowledges that the digital environment was not created with children in mind, but however, it is a very important part of children's lives nowadays. So it is important to recognize that the child rights apply both online and offline. Then moving to the EU level, starting from the criminal law, we have the main legislation is the Child Sexual Abuse Directive of 2011, and it harmonizes offense definitions and also minimum penalties across member states. However, it predates encryption, live streaming, and AI generated CSAM, and that's why 2 years ago its recast was proposed to cover these gaps. However, the recast has not been adapted yet, and it's in negotiation process, not started the trilogue negotiations yet. So it's in initial steps, if we might say so. Then going into the platform obligations, we have the Digital Services Act, which obliges platforms to assess their systems against their platforms to assess their services against systematic risks and to remove illegal content, which includes also child sexual abuse material. Article 28 DSA is the main article related to children, and together with the Commission's guidelines on the protection of minors, they require platforms to ensure a high level of privacy, safety, and security of minors by design and by default, which means that the DSA requires businesses to also focus on primarily on the best interests of the child, and especially when their services are directed to children or are predominantly used by them. However, we need to keep in mind that the DSA is not child sexual abuse specific, and here this leads us to the next legal framework, which is the proposed child sexual abuse regulation, which is the most politically contested framework or instrument in this whole framework. What does it do? It is it allows the detection of 3 types of material: known child sexual abuse material, new, so previously unknown child sexual abuse material, and materials related to sexual exploitation of children on the internet, or what we know as grooming. Until April this year, we had the interim derogation to the e-privacy directive, which allowed platforms to voluntarily scan their services, interpersonal communication services, for the detection of child sexual abuse material. This interim derogation expired in April because the European Parliament rejected its second extension, which leaves us in a legal loophole or gap currently. So platforms do not have any legal basis to voluntarily scan for child sexual abuse material online. This is the gap that the CSAR proposal is supposed to fill, but it is in trilogue negotiations. It's been a difficult negotiation process, something else. Where we stand now in the CSAR proposal is that the initial mandatory scanning obligation was dropped, and now we have the idea of creating an optional permanent voluntary scanning of child sexual abuse material, but with a future review clause, which means that the mandatory scanning is not actually completely out of question. what I'd like to highlight here is that the centerpiece of the enforcement architecture of the CSAR proposal is the creation of an EU Center on Child Sexual Abuse, which would be an individual agency that would manage an indicators, a system indicators database. So the idea is to split or to move out of the international NACMAC database and create a European-based CSAM database. And also the center would channel the reports to Europol and to national law enforcement agencies, and also provide free detection technologies to providers. So that in this case, providers cannot, for example, claim that they do not have the means to implement the detection requirements. Then moving to the law enforcement side of the framework, what investigators can do is primarily governed by the Law Enforcement Directive, which is an equivalent of the GDPR, but applying particularly to the law enforcement. It authorizes the processing of personal data for prevention, investigation, and prosecution of criminal offenses under strict conditions of necessity and proportionality, and with heightened protection for special category data. Very quickly moving into the next one is we know that law enforcement for their investigations apply AI tools, and the majority of these AI tools fall within the higher risk category of the AI Act. So also AI Act is applicable, and which means that they trigger a series of conformity assessments, transparency obligations, and human oversight. And the last one, but very important as well, as of August this year, we will have the e-evidence regulation entering into force. We heard, I don't know if some of you were in the previous session on the e-evidence package this afternoon in this same room. So what this will do is that it will give investigators significantly more power and faster tools to cooperate for cross-border exchange of e-evidence, and particularly in content, traffic, and subscriber data in child sexual abuse cases. And what is very important here is that based on this regulation, the exchange timeline will be 10 days, and for response times through a European production order, instead of what we have now, 10 months, which is a huge amount of time for investigating these kind of crimes. And it will be also 8 hours for emergency cases. That's all, thank you.
Thank you, Desara. So we'll jump into our questions here, and Desara, we'll start again with you. How then can online CSA detection and reporting be designed around children's rights and victims' interests, not only law enforcement efficiency?
Yes, that's a very good question, because investigating online child sexual abuse, it's a very hard process. It's emotionally draining and even overwhelming. And everyone involved in this investigation pipeline, like from content reviewers to prosecutors, investigators, and social workers, they all experience burnout. And it's very important that during the whole stages of this pipeline, they center the victims. And they do not treat the victims as evidence or as something that they need to preserve, but they treat them with dignity, with respect, and keeping in mind that they have rights, and then that their dignity, agency, and also a recovery are the ends in themselves. And I think the most some of when it comes to the investigation part, some of the design approaches, because I think this is it's a design choice, and it should be a choice in all of the steps of this pipeline. And some of the approaches might be minimizing re-traumatization, for example, such as by recording the interviews of the child victims rather than having them to go through many interviews in all of the steps, and limiting the number of interviews means that they don't have to relive their experience all over many times. Another approach would be not putting the burden on them to follow the procedural steps on reporting, but also through the whole investigative process. Another very important one is protecting their anonymity. The anonymity of both victims and witnesses, because in most cases the survived victims are also witnesses in the cases. What we've been seeing, probably all of you have seen, what happens actually in practice is that we see in a lot of media outlets, but also social media, that the names and even images of child victims are publicly available online. And I've even seen cases, court documents being released with, they have anonymized the names of the child victims, but then all the other details are made public, like the neighborhood where they used to live, their family issues, like what do their parents do, the school where they go to, and sometimes even the initials. So then I don't know whether this can be considered anonymity anymore, because anyone can identify them very easily. And then another approach should be providing integrated support, so both legal, health, and psychological, all in one safe environment. And I would like to mention here an example from the CSAR proposal, which is, I think, a very good example, because they have introduced the creation of a victims board inside the EU Child Sexual Abuse Center that I mentioned before. And this would be composed by victim survivors, adults, but that went through child sexual abuse themselves, and also experts in the area. And I think this is a very good approach, because it would give a voice to the child victims in the process. Thank you.
Okay, thank you.
Yeah, thank you. I think what I want to bring today is experiences from two different parts. The research that we did on Chesagram, where we interviewed 20 survivors of online grooming who then went missing and experienced child sexual abuse, or experienced child sexual abuse and then went missing after they had been groomed. And experiences that we've had in the 5 years that this CSAR legislation has been ongoing, and where we've at some point joined with other child rights-based organizations to try and influence that legislation to focus on children's rights. So that's where I'm coming from. I think one of the things that we're saying is that we need a rights-based benchmark for detection. I think there's a lot of focus on detection and finding victims, but it doesn't look at children's rights. It doesn't look at reducing harm. And I think a good benchmark for detection systems should be, do they help children? Do they help identify children? Do they help timely protection and prevent further harm across the systems? And that means connecting detection with takedown and with support to victims, which at this point is not what's happening. Detection is going to prosecuting perpetrators, and that's really what detection is connected to. And it should be connected to taking down the material right away. That shouldn't be two different processes. That should be one process. When it's detected and it is child sexual abuse, please take it down, protect the privacy of this child. And the second one is to really make sure that this victim is found and it is immediately referred to systems. That's on the side of detection. I think, there's a lot I could say more on this, but I'm quickly going to the reporting part of it. Again, reporting is often done by children, but these reporting systems are not child-focused and not child-centered. The reporting systems should be connected to support. Again, they should be designed in a child-friendly way with involvement of children. They should be reassuring, simple to understand, and there should be information, both in the detection, but definitely also in the reporting on what is going to happen next. Because I think one of the most scary things for victims, and that's what we found from those interviews, is like not knowing what is going to happen with all that evidence. Where is going to go? Who is going to see this? What is going to be kept? They have no understanding of what happens when they report that this might be published online and is going to be public for years and years and years on. That shouldn't be the case to begin with, but they should also have some understanding of what is going to happen, how that is going to be safeguarded. And I think that's one of the biggest uncertainties that victims who need to feel comfortable to report, particularly when it's about grooming, which I think is likely going to be very difficult to keep in the regulation, because detection isn't at this point as sensitive as we would like it to be. I would like that to get better. And that's really important because that will help us prevent grooming. I just want to say all of that again. But in terms of that to get to get better, we really need to look at reporting. So right now, self-reporting is actually one of the most common things for grooming. And when that happens, we really need to give victims an understanding of what's going to happen. And just one good practice that I want to share is the Barnahus model. The others might want to talk about that, so I'll just leave it at that. But I think that's one of the most common things that victims said to us in this Chattergram research was that the way in which they were being interviewed and the fact that they were being re-interviewed several times again, the re-traumatization that happens when they're being interviewed, the lack of training of police officers, which Mary Collins Foundation did in that project. The training is so important. And Barnahus model is a way where victims are in a very nice environment, in a safe environment, interviewed, taken seriously, and that happens once. The video is taken, is safeguarded, and that then is the evidence. And I think that's a good way to go forward.
That's great. Thank you. Tamara, or would you like to add anything?
Yeah, I mean, just in general, this seems to be the issue with all sort of coercive and controlling crimes, in that the onus is put on the victim to carry their case. It is put on the victim to build their case, so you can expect children not to be able to do that, and to basically live with whatever is thrown at them as they're being pushed through this process, which is neither clear nor straightforward. So the role of technology should be to support a trauma-informed system that is being built by people who understand the space, they understand the needs of the children, but also understand the investigative process. There's lots of really good work being done for that. And it also needs to support the investigators into preserving their humanity and not being overwhelmed by seeing so much material and seeing so many victims. And what often happens is weighing one victim against another, because each person's pain is their own pain and they're carrying it. So it shouldn't be just because this week you saw a case that's really, really awful, that something less awful is not that awful for that person. So it's important to actually, help people reduce victim blaming from their work, to help people reduce the trauma that they're experiencing. So there are systems that people are building where images are indexed and explained using AI, and they're grayed out until somebody needs to see them. So they don't actually have to see them, and they can search databases of images and look for particular features, like a particular door or a particular window or a particular background feature, without seeing all of the images. And that preserves the anonymity of the victims, but also helps the investigators. However, what I find in policing systems is that there isn't enough good data science often, and some of the there isn't maybe enough testing done to see if these systems are working, as well as they should. But I think there is work being done, but all the new technology people are trying to introduce doesn't necessarily need to speed up the current processes. It needs to help the new processes that we need to build from basically a social science side first, an investigative side first, and then introduce the technology that helps.
Thank you, Tamara. Karen, is there anything you'd like to
Yeah,
add?
just briefly. I've worked internationally, and now I work in the UK setting. So I'm speaking to a UK experience right now. I think it's interesting to kind of compare what's happening, particularly in the EU, with what's happening in the UK, and certainly regarding child rights generally within these investigatory processes. I would say that we're very behind. And that's putting it mildly. In the UK, we are not au fait with this. It is not a priority at all, which is a real shame. We might do okay in other aspects, but this is it's a real failing, I think, of the system. So that that's down to various factors, like we don't have a direct incorporation of the UNCRC. Scotland has done it. But the picture across Wales, England and Northern Ireland is less complete, which obviously means that some of those obligations are not being passed along, so that children can't access their rights in the way that they should. and that affects CREAs as well. That's not happening across the board. So it would be my view that we need to prioritise children within the criminal justice system. It's not happening to the extent it should, but I did want to share one good practice example from Northern Ireland, which is where I live. There, in 2019, we had a very high-profile case involving sexual abuse. Now, this was sort of the transition age, so young women who had, brought forward alleged abuse by some fairly high-profile people, and it was a big case. And as a result of that, there was a review into sexual offences in Northern Ireland, and following that, there were some changes made for children specifically within the criminal justice system. So one of our local judges initiated a pilot for under 13s. And this was a way to prioritise all child sexual abuse cases coming to the system. So probably like most places, the system is bloated, and there are often delays, and that, access to justice even itself is being compromised there. So this particular judge wanted to bring about some changes herself and initiated this, brought in some partners. And basically, when a case of child sexual abuse involving an under 13-year-old came through, it was going to be put to the front of the queue. So no longer just sitting and waiting to be addressed. It got an automatic transfer to the top of the pile. Now, obviously, that means there are various cases at the top, but this was a way to try and address what she called the grave injustice in delays. So trying to prioritise that child's right to timely justice. And as a result of that, the majority of cases now coming through are dealt with fully in 6 months, which is fantastic. That's fast, right, compared to most processes. But, I mean, you might have already realised in what I've said, that's for under 13s. So we have an inequality still for 13-year-olds plus in the system, so that's no good. And just to pick up on Barnahouse, the government, the UK government recently committed to fund a rollout, a national rollout of Barnahouse. But while that's good, it's pretty slow. It's been slow to get to this point, and I would definitely argue that within those Barnahouse models, we actually need a huge number of specialists trained in technology-assisted child sexual abuse because of the number of cases coming through.
Okay, thank you, Karen. We'll stay with you. What do legal debates miss about support needs, evidence handling, and secondary harms in the context of trauma-informed and victim-centred practice?
Okay, so you might be aware, within the online safety space, we will often talk about safety by design. That's routinely said. I think most of us believe in it. But when it comes to the investigation of these cases, we actually need to get meaningful, embedded, cross-sectoral child rights by design approaches, which don't exist, in my view, not to the extent that we need them. Many of our processes are harm-causing and rights-denying, which is no good. Now, recently, just this week, research I did got published on mental health and support needs for victims of technology-assisted child sexual abuse. And that research revealed that support needs for victims of TAXA are really specific, and they're extensive as well. So we find that victims of this type of abuse often experience feelings of culpability, complicity, and responsibility for the abuse. They also experience guilt, shame, and embarrassment, and silence and blame. And as a result of that, therapeutic intervention. So if you look at the investigatory process as a whole spectrum, which takes in therapeutic care, we have been able to sort of isolate some of the things that need to happen within the clinical setting to unpack those mental health harms. So things like validation, so acknowledging what the victim has been through by the clinician is super important. they need to be able to empower the victim by helping them understand how the harm has occurred. You know, what is technology-assisted child sexual abuse? What is grooming? Perpetrator processes, and information about recovery, giving some sort of realistic ideas around that as a means of hopeful equipping of the victim. Really importantly, apportionment of blame came out as well. So where the victim has self-blamed to some extent, having a therapist who will actually help acknowledge, no, the fault lies squarely with the offender, improves recovery. And then normalization was another thing. So by that I mean, we saw lots of victims who felt betrayed by their own bodies because of what had happened to them, as in when they were abused, their body reacted like physiologically, had arousals, as you might expect, but that was very deeply shaming for the victim. But helping a victim understand that is a physiological process, you could not control that was normal, actually has helped victims recover really well and kind of get over that sense of self-betrayal from that arousal. So I suppose I'm highlighting that research just to show that these are some things that are missed in some of the processes. I do want to give some other examples of the frictions that we see, things that are missed within a UK setting, and these are quite broad, so I hope you stay with me. But in terms of the Online Safety Act in the UK, it's often kind of lauded as like a gold standard piece of legislation, but we don't have any specific legal redress for victims of online child sexual abuse at all. Organisations like ours are trying to challenge that. We often see victim and offender displacement or role reversal in court processes. So Orla and I were just talking about this before we came in. You will often have the mental health impacts of the offender weighted more heavily by a court than the mental health impacts of the alleged offence on the child victim. There's also a lot of victim blaming language which has come up as well, the kind of responsibilization of children for their own harm. So police or social workers asking, well, what were you doing talking to someone you don't know online? Why did you take a picture and send it to them? Not necessarily stepping back from that and saying, we have to remember an offender was present with that child, albeit down a screen, directing the child to do that. Other problems within the system that we work on and have noted are the use of good character evidence in court processes. So where offenders are allowed during the mitigation part of the court case to introduce evidence of their good character. So if victims having to sit there and listen to the counsel for the offender describe why this person is a good person, even though you could very, very strongly argue and defend that perhaps their good character goes to the offending. It lends itself to grooming, but somehow we seem to be letting that through. Contrasted with that, victim impact statements, which are processes done in the UK. While we do have those where victims are allowed to explain the impact of the crime on them, these are not read out in court automatically, whereas those mitigations that I've just mentioned are allowed to be introduced publicly into the court. There's definitely a strong offender rehabilitation process in the UK, and I want to be fair, rehabilitation has its place. We are not anti-rehabilitation, but at the same time, we would argue that there's a disproportionate emphasis on the offender's rehabilitation over and above the victim's child rights and their right to recover from what's happened to them. So a UK case that occurred in the past year or so, so an offender had category A, CSAM, plenty of it, and other category images as well, across multiple devices, had been offending for many years. And although the judge noted that this offender, so the conviction, this was at sentencing, so the conviction happened at sentencing, the judge noted that there were countless victims, albeit maybe we couldn't find them. But the judge said that this offender should have an opportunity to rebuild his life from that point on, and that rehabilitation was appropriate. Now, maybe rehabilitation has its place, okay, but to say that he has a right to rebuild his life when these victims aren't necessarily being found or having the help and support they need it's quite hard to make sense of. And then other things we see in our own practice, we work directly with children and young people who've experienced taxa. We've had children tell us that when their phones or their tablets are taken by police for forensic evidence, obviously that can take a while, we know that, but offenders will also have their devices taken away, but there have been examples of police forces who have replaced an offender's phone, a cheap phone, like a burner phone or whatever, a cheap phone, but they will not think that a child might also want access to a phone for the same reasons of keeping, in some sense of community, reducing isolation. And then the other thing we see a lot of is criminalization of children and young people for sexting. So where there are, there's clearly an offender, but because the systems are so process driven, they're not people driven or children driven. It's almost like the police, they take the guidance and they just say, well, system says no, this is sexting, without looking at the nuance around it. And so victims are actually being criminalized for the abuse that's happened because of an offender. We also have seen suspensions in school for victims, so where they're displaying kind of very normal trauma reactions. Perhaps their offender is in the classroom with them. That's how it's occurred. And those children are suspended because they don't want to sit in the same room as their offender. So they're excluded from school, or they have like notes taken, against their kind of school data, which doesn't feel good either. And then linked to that, we've seen examples where police and social workers have said that the child is non-compliant with the processes. So that's noted, and then they don't necessarily get offered the same services and care, even though those are trauma responses, but are ultimately being weaponized by the processes around them. So those are some examples of where we're getting, I don't know, there are lots more, but those are examples where we're getting it wrong in the UK. And that's why the Mary Collins Foundation is trying to highlight these things and bring some change in these areas.
Thank you, Karen. Tamara, have you anything to add?
I might skip this one and just...
Okay.
Yeah.
I think I already mentioned a lot that's relevant here in terms of making sure that the investigative and judicial process doesn't re-traumatize, and I think you've said a lot about that. I've mentioned Barnahus. I just want to say that within the Victims' Rights Directive, EU level, and the Directive on Violence Against Women, there's already talk of this need for one place, one interview. So I think in terms of victims' rights in general and in women's rights, that is recognized, that's important. And so I hope in the CSA directive that will also be recognized, that for this taxa, as you say, that there will be that kind of interviewing. And indeed, I think one important thing that you mentioned is the need for specialized people who know what technology-assisted child sexual abuse is and who understand that there is maybe not just one person on the other side, but groups of people on the other side. Because one of the victims that we interviewed in Chesagram was somebody who had been abused by, I think, more than 100 abusers. So she was being trafficked. She had been groomed, went missing, and was being trafficked. And what she said is like, there's so much victim blamings toward children who are then asked, like, but why did you send that picture? It's such a recognizable comment to be made. And what she said is, well, on the other side, it's not one groomer. There are grooming handbooks online. They sit together in spaces that we don't see and that hopefully some investigators might see. but that's where they encourage each other and give each other advice on how to groom a child. She's not responding well to this, try that. While that's happening, so it's not a 14-year-old against an 18-year-old or a 20-year-old or a 30-year-old on his own. I'm just, the genders here, I'm just using the average or the usual. It is against a whole group of people who are giving each other advice on how to do this, and a child can't win. And so I think the victim blaming and the criminalization of children is really something that is concerning. Sometimes victims are also groomed to groom others. So again, what we also see is peer-to-peer grooming, which often is linked to being groomed by an adult somewhere who's telling the child how to groom others into the abuse. So that's also something that we see happening. So I think definitely criminalization of victims is something that we see a lot, also in Europe, and that is very concerning. So I think that's maybe one of the important things we miss. Training I've mentioned. I think taking into account the needs of specific vulnerable groups. And here I want to mention LGBTIQ children who are specifically sensitive to being groomed online, but also what we're seeing a lot in our field of work is children in migration and unaccompanied minors who are also being groomed online. Given advice on where they can find support, but then are being abused because of basically targeted online into supposedly safe support services, but then actually being groomed to reside with people who want to make abuse of them. So it's really something that we see, and that needs specific support services and specific understanding, I think, because we don't know how these groups function so well, and there's not enough research on this.
Thank you.
I'm not an expert in this one, but I just wanted to say that it's very sad to hear the issues that were mentioned by the colleagues. And also that reminded me also what you were mentioning, that there is also the problem that perpetrators are sharing online manuals on how to abuse children, so instructing each other. And it also reminds me of an initiative, I don't know if it was in UK, but we also thought about having this in Albania. I used to work as advisor to the Minister of Justice, and at one moment we were considering of whether it is appropriate to create a public register of child sexual abuse perpetrators, so that everybody would know who they are, where they live, and this would also be like a form of protection in the environments around the children. But there is also the counter side of it.
It was almost pitchforks at dawn in my village recently, so I don't recommend it, to be honest. I was going to say is when you were saying those about the online manuals, one of the things that's not been mentioned here is sextortion yet. And, that's not even sometimes considered as CSAM, really. It's like considered as like fraud or like, and actually, people are like, children are killing themselves for being over this and being extorted. And the other people maybe not even considered your straightforward CSAM perpetrators on the other end, because those could be even people who themselves have been trafficked and put into rooms to extort people online. And they've been given the manuals, and they're punished, and their families are punished if they don't do this. So the issue is absolutely very complex, and sometimes it's not even driven by the psychological factors that people think are driving the perpetration.
No, it's about money. And sometimes it's even AI
that's doing it,
produced images of the people who are being extorted, but it does lead to suicide. So it's very much, it's very complex, absolutely.
And as far as, and it's come up a couple of times, but the grooming language actually is very identifiable in the new natural language processing techniques that we have available now. Really, really helpful in identifying grooming language. And so I'm happy to talk to anybody offline about this, because that's what we build. But you can, because grooming requires specific patterns to get a person into a particular state. Now that changes for different people. However, the psychological acts of breaking down barriers and getting people used to sharing more and more information and being uncomfortable, like being more comfortable with things that make them less comfortable, the perpetrators also use techniques where they systematically remove objections somebody might have to meeting them in person. And there's all sorts of psychological techniques that are actually, through the manuals, geared to specific type of personality somebody might have because of where they've grown up, what child they are in a family, like first, second, third child, or it's incredibly, these grooming manuals are incredibly complex. And so therefore, none of this should be, but most people don't know this. And unfortunately, most social services, most police officers, most people who deal with these cases don't understand how much systematic psychological abuse is being directed at people who are being coercively controlled. That yes, we always get to this belief, even if they want to believe it. But my worry is with the one interview thing, although definitely the thing to do, is if the wrong person does it. The first person that child encounters, the first person who takes that interview is the person who is going to set the tone for the rest of the investigation. And unfortunately, as we know in the UK, for example, because of the massive cuts that had happened in police force, and everybody who works there has 5 or less years of experience. Not everybody, but a sizable proportion. So what you're actually having is children having to deal with other children who've been basically groomed. I'm not saying, but people in their 20s have different attitudes towards life. And so you get these, much more relaxed. Well, I've been through school now, sexting is normal then. This is, so yeah, it's a complex problem.
Thank you. Tamara will stay with you and ask the third question. What do good technical safeguards for evidence gathering and preservation, due process and victim support actually look like in practice?
So yes, basically being trauma informed from the beginning, being able to gather all the devices, but like you said, being careful not to overstep your bounds in disenfranchising the victims from their community, because that's what the groomers do, don't they? They isolate you from your peer support, they isolate you from your family. So everything needs to be done to actually support people to make them feel like they're part of the whole in the community afterwards. The devices, they cannot sit untouched for months and months and months, which is what happens in a lot of crimes. But you said that there's an effort to process them faster, but there's such a massive backlog. I think in UK there's over 20 or 30,000 devices forever waiting to be processed. So nothing is processed. But and when they download things, they actually just take the whole copy of your hard drive. So they take everything, and then they often use everything for you or against you as well. So it's difficult. There are also tools that are being developed at the moment to help police interview the suspects as quickly as possible. So as they get the device off of somebody, they try to scan it as quickly as possible, and then scan the conversations to pick up the markers of grooming, and to actually focus in and have the right questions they can ask at the time when they still have that person in custody. So I think basically being able to process the data when you have a chance to talk to somebody, being prepared, and those are the types of tools that we need to help with forensics in these types of cases. But yes, also detecting grooming language, explaining to people what grooming is, what the methods that were used on that person for grooming, and then tailoring the services and the support based on what was done. That all of that can be enabled through new technology.
Thank you. Is anything you'd like?
No, she said everything that I would know.
Anyone else want to add anything?
I would just like to add this. The question is around technical safeguards, but I believe that, at least in the UK, that we need to do a lot more on the front end about these crimes. So we're in a situation where we're actually kind of at an impasse around CSAM. So we are getting convictions for CSAM, but that isn't necessarily translating well into like a deep public understanding around the nature of those crimes and what it's doing to victims. And even maybe even more strongly, what I would say is that we really are not doing well on deterrence generally for CSAM offending. So we've reached this sort of stalemate where we get offenders coming through, convictions are happening, but they effectively get a slap on the wrist. That's it. It's very rare for them to get custodial sentences at all. So we're not really meeting the purposes and principles of sentencing in the UK. And I think there is a piece that is needed to educate the public, including offenders, that CSAM itself will not be tolerated, that actually we're going to institute a zero tolerance approach to this. We're going to stop regarding it as low-level sexual offending against children and start calling it what it is. That hasn't happened, but it is something that needs to happen in order to turn the tide on this particular form of offending. So I would argue that is a technical safeguard.
Sorry, I just want to say as well, on topic of rather not policing side, but the technical safeguards, is that there needs to be friction introduced into the ability for people to obtain and get these materials. So at the moment it's incredibly easy, and then that actually obviously exacerbates the problem, because more people see it, the more their brains get wired to absorb this material and becomes more normalized. So what we need is basically the whole technological system to get together to introduce difficulties in accessing CSAM, as opposed to sort of grok style, making it available to everybody who will pay. Basically.
Maybe to say, if we're talking about technical standards and safeguards, but maybe I just want to reiterate that what we need to have is a rights-based benchmark, which connects evidence gathering and evidence handling with triggering, reporting, support needs, finding the victims. Like the incident that you described, where one person is absolutely needs to have a life, but we're not looking for these other victims, and we're not supporting them, and we're not taking their material down, or we're just, we take the evidence and we use it for a process that might not even lead to a custodial sentence, and then at the same time this material keeps going around. That is completely, that's not justice, I would say. That's really not what justice is for. So I think a rights-based approach to like the safeguarding of both the evidence but also the victims. That's maybe.
And in SALVUS, we're definitely seeing and hearing from law enforcement in terms of the confiscation of phones. The powers differ across member states. So some law enforcement agencies can obviously take a phone once they suspect someone's a perpetrator, and it's not as easy in other jurisdictions. So there's that kind of element as well.
I just wanted to add that this is the question is about technical safeguards, but this is where the law enforcement directive that I mentioned at the beginning comes into play. And based on this directive, law enforcement cannot process data beyond what is strictly necessary. Yes. And there's particular attention needs to be paid in the case of children's data. And also in the case when they are deploying AI tools for investigative purposes, then they need to have adequate safeguards and human control. And I think this is very important also for what you said from a rights-based approach.
Definitely. Anything to add? Is that fine? Okay, so we'll go to our final question, Ahi, if that's okay. Who should verify and oversee the effectiveness and proportionality of online CSA investigative measures? Should it be DPAs? Should it be child protection authorities or the courts? Who's best placed? Or a combination?
I think we had a combination of actors who need to look at this with judicial oversight to make sure that rights are being respected. And I think that is really to make sure it's lawful, necessary, proportionate, and so on, under fundamental rights standards. we did feel that it was necessary to keep involving researchers in terms of like the verification role. One of the things we noticed in Chattergram, we developed a tool that was going to do, we looked at public conversations, so we didn't go into the private messaging. We just, so we developed a tool. CERT was the organization we worked with. They developed a tool to detect language, of grooming language on, I think it was a live stream of videos, and on different platforms. And they said, well, the evaluation, not just at the deployment stage, but regularly, because what these AI tools do, you need the researchers to have access to these conversations to ensure that the AI is continuing to evolve in the way that it's supposed to evolve. Then there needs to be sometimes some human control, and the researchers need to be involved in that. So they actually need to, work at, I think also, across languages and so on. I think there's a role for civil society organizations to continue to ensure that it's, particularly organizations like Mary Collins Foundation, I would say, or like our hotlines who have contact with victims, to ensure that the oversight is also taking into account their rights and their perspectives on how they experience the procedures. So that's, I think, something we found really important. The European Commission and Digital Services Coordinators have, of course, their legal role, but maybe others can speak about what they can do. But I wanted to just say, like, researchers and civil society organizations have a role in that oversight. So that maybe I should have spoken last on this particular topic, but I said what I needed to say, so I'm going to leave the rest to others.
I also think it's a collective effort, and it needs the involvement of all actors, and everybody needs not only to know their role, but also to sort of make sure that also the others connected with them work in an appropriate way. And here I wanted to highlight the role of the proposed EU Center of Child Sexual Abuse in the CSAR proposal. I think it has a very important role in this regard, because it would be, and I think it simply follows what the EU has been doing with the other laws, like with the AI office in the AI Act, for example. And it would contribute by making available the indicators which everybody would rely on, and also the technology that the detection would rely on, and also it functions as it would function as a quality control, because it would filter information that would go to law enforcement and particularly to Europol, so that they also don't get overwhelmed by a lot of information which might reporting, which might also be false reporting. And we know the importance that this has in the effectiveness of their work into processing what actually matters, the real cases. But it's important, I think, and I think this would be like, even in the case that the CSAR doesn't get adapted, I think it would be important to have this kind of agency, this kind of center. But we also need to keep in mind that at the current form, how it is in the text, I think it's not really clear its relationship with Europol and the independency from Europol. So this would need to be clarified.
Yeah, absolutely.
Tomorrow, is there anything you want to
I mean, the only thing I can really contribute to is, yes, you're right. Any AI system that's deployed needs to be continuously tested, verified, and updated. So nothing can, you can't just let things go and deploy them and hope for the best and let it run. So yeah, that's all I got.
Anything you want to add? I think as well, in terms of children's right, empowering children within the online spaces is also really, really important. To be aware of the pitfalls and the, perpetrators that are there and what they do. So empowering children, I think, is a really important aspect of this as well. So is there anything anyone would like to add at the end of this that we maybe haven't covered or we haven't touched on that's really important?
I think there's so many aspects to this in terms of like what's needed. I think there's a lot of, particularly if you talk about grooming, what you just said, like we are getting better and better at detecting it. And I think one of the things that I'm extremely frustrated about is how grooming has kind of gone out of the scope of the CSAR regulation, because it's still there, but like we'll see how it. We will fight for it, but like it's not an easy one to keep, and I think how important it is within grooming because that is actually where you can stop the abuse. If that's being detected, you can stop the abuse before it happens, and it's the only way to stop the abuse before it happens, and that I think is something where I really there are so many ways in which we're getting better at detecting these, and there's so many different ways to do that. So I think that you cannot underestimate the role of that potential role of that EU Centre. I really hope it does get established because I think it could play an enormous role in setting standards of what could be done, but also ensuring the rights and how important it is for that to be set up in a way that it has the trust of the public, and therefore I think the independence of Europol, however practical it might be to put them in the same building, but to really making sure that that's something that is trusted and safeguards victims' rights. So yeah, I think that's something I just wanted to highlight.
Maybe I can add something. I think the main issue with the grooming and why there is all of this debate is that even if we have a perfect technology that can detect grooming words, we still have the issue that it would mean going into one-on-one conversations. And these are supposed to be private, and we never know what this, under the justification of grooming, what can happen by different governments, by different institutions. So privacy is a big issue in this. And also, do we then, the other question that comes is, do we then have the necessary or the effective technology to detect who is a child and who is an adult? In order to be able to scan only conversations between a child and an adult, because to detect grooming, we need to scan conversations that happen between a child and an adult, not all
or
conversations.
peer-to-peer grooming happens as well.
But this is why
really
people want to put the technology on the children's devices as a safeguarding thing, as opposed to like let it roam freely on the internet, right? I mean that's why it's a low bar.
There are solutions.
Children don't have privacy; they have parental controls.
There are solutions to it.
I would argue against
I mean,
that.
no, this is the topic of the panel, but most people consider that it is completely appropriate to control children's devices in various ways, like at the moment, right? But yeah, it shouldn't be again put on the victims to protect themselves, right?
Interesting.
I think we've some time for questions, if anyone has any questions.
I think that was the perfect segue from your question. Thank you so much. This was very insightful. My name is Ana Nelas. I am the Policy Officer for Digital Rights with the European Sex Workers' Rights Alliance. And also I work as a sex educator, and I work with survivors of technology-facilitated gender-based violence, specifically notification apps. So this is where I'm coming from. First to say that it might seem like we are on kind of opposite sides of the spectrum, but I don't believe that. I think there is so many similarities between the sex workers' rights movement and children's rights movement, including the criminalization being a prerequisite for more victimization. And my question is, so on detection mechanisms, right? First, how are they going to be trained? Because we know that a lot of these AI models that will scan the internet for CSAM materials are trained on CSAM. And in a lot of these cases, the victims did not know that these materials were being used for that purpose. So that's my first point. And on the second point is, when it comes to check control and this more invasive scanning, how can we make sure that this is not being used as a straw-man argument to crack down on sex workers even further, criminalize them and victimize them? Because I feel like that is a push and pull, especially, I work as a sex educator, and I see that this detection mechanisms when it comes to words is not precise at all. My Instagram was deleted like 2 weeks ago on grounds of human exploitation, and I do sex education and I'm an adult. So how can we trust that, right? So these are my two questions. Thank you so much.
I'll take the non-legal ones. Right, yeah. Any machine learning algorithm needs to be trained on the data that it's going to be doing. So I don't do image necessarily work, but yes, for images, definitely you would have to train it. And I have no idea how they trained the systems at Interpol that they're using, but I expect they had to in some ways. With the language side, it's a little bit different because large language models are pre-trained on language already. And because you can prompt engineer a lot of descriptions, you don't necessarily have to have a lot of training data to get things going. However, you will still need some test data. Now, depends what you're looking for, right? You get done by a keyword-based search thing, which, fires off on any. It's the same thing that's keeping all the basically women's health products off of off of the internet because they use the words like vagina, which is not allowed. So there is, but what I'm talking about is looking for patterns of behavior, not one-off statements, not, they're patterns of behavior that need to be followed to get somebody into a situation in which they're going to share information or push their boundaries to do something they're not interested in doing. So it shouldn't fire after one or two messages. It should fire after, you've seen a couple of indicators of a pattern of abuse. So so it's about how you design this system is what your end goal is. But obviously keyword stuff is cheaper. You can, some systems are more expensive to run, some are cheaper to run, and you can't deploy the expensive ones en masse for everything because you just burn down a forest. Yeah. Legal questions?
I might say something about the technology. I'm a lawyer, but I've been analyzing from the legal perspective the technologies that you were questioning about. For example, currently the best technology that we have is a technology for the detection of known child sexual abuse material. For those who don't know, known child sexual abuse material is material that has been already identified as being child sexual abuse, and it's included in a database. Currently, we have the NACMAC database, which is an international one. For the DNA is a technology developed by Microsoft to detect or to match images found in the internet with the images found in this database. And how they do it is not like viewing the images, but is through a hash matching technology. So each image is converted into hash, so it's divided into grids. Mm-hmm. It's difficult to explain by words if you don't have the video, but it's divided into grids, and then the grids are assigned numbers, so it's a code. Each image has a unique fingerprint and unique code, and then you match it with the images in the database. And if it's identical, it means it's CSAM, but also the technology is said to also identify not completely identical, but a little bit altered images. So when they resize or change the colors to try to skip the system, but it can still identify them. It's being used a lot by law enforcement and also by platforms. But recently there's been, I don't know, maybe you can say more in this regard, but a lot of tech experts have been criticizing the system related to not being that accurate as it claimed to be. And there have also been cases of, for example, parents being flagged as sexual abusers because they were sending naked images of their child to the doctor for some particular medical issues. And then we don't have any proper technology, to my knowledge, that is effective for detecting previously unknown child sexual abuse material. And this is also why we got stuck in the discussions for the CSAR proposal. But there is also another way of detecting issues of child sexual abuse and grooming, which is undercover investigation. Many years ago, there's been a study about police using a sort of avatar that looks like a girl trying to go into undercover investigations, into conversations with perpetrators, suspected perpetrators. but it's still unclear whether undercover investigation is allowed, and in all different member states have different approaches to this.
Yeah, thank you so much. I was really happy to see an all-female panel. Thank you so much for sharing everything. This is a topic that's really on top of my heart. I'm actually not for scanning, but I'm really happy that was not the focus of your, because I heard so many good things. I think because you have to focus on the goal and not on the tool. And scanning has, it's really, you described perceptual hashing, that is with fingerprinting, but most CSAM nowadays are videos and not images. And that's really difficult, and you would need AI. And it would have to be omnipresent, otherwise it wouldn't be effective. And there's a real issue, and that's, fortunately, I think that's why the bill the proposal has not been accepted yet. Then again, it's really important we do something. And I heard so many good things like helping victims, maybe have reporting centers, put more in policing, because it's so, even if we would detect, police would now not have the capacity to do anything about it. And I maybe also think a focus on people with porn addictions, because we tend to think it's people who like children for sex, but it's usually also porn addictive people who want stronger and stronger material. We could maybe educate them, make them aware, help them, talk to them, but also talk to small children about what is appropriate, and tell your mom or someone at school if you don't feel, if someone touches you, so awareness is, I think, also really important in this discussion. And the tools for the police, good tools, so like your example of undercover investigations, so really targeted stuff. Yeah, so I hope we will make small steps, but I know it's really difficult. I'm not really having actually I would have had the same question as she asked. Who's deciding to put what goes in there? Because who's watching the watches? Because there would be I don't know how to put it in English. So we say in the Netherlands, sliding off a scale.
Slippery slope.
The slippery slope, exactly. So,
That's always the argument, yeah.
Could I'll just respond to you around the police issues there. So we do engage a lot with police. We've had police come to us proactively who are engaged in internet child abuse investigation teams, or POLIT teams, like pedophile online investigation teams, who have told us that they are just overrun with cases, right? So to your point about funding and about training, it's essential, because they don't have the capacity to deal with the amount of cases coming through. So there's something we're doing wrong in how we're addressing that. And then to speak to the porn issue, like the academic evidence around the escalation pathways between porn to extreme porn to CSAN to then contact offending is well established. I'm happy to say that in the UK lately we've been able to get some really interesting offences included now in new legislation around this. So like the banning of incest porn and age play porn, so when people are trying to appear as children, as one kind of deterrence really against those pathways occurring, which is really welcome, I think.
I wanted to ask a question.
Hi, I'm Helena. I just finished my PhD at University of Bristol in domestic violence, and I'm qualified in China and England and Wales. So my external examiner was Rosemary Hunter, and in my viva we were discussing that in terms of criminal justice response to domestic violence or sexual violence in general, we can see that there has been two trends like happening at the same time. I think it has been like one specific, very trending practice is like the anti-carceration practice, and in the UK we have been discussing restorative justice a lot, right, in terms of how to achieve the rehabilitation of the perpetrators of domestic violence. But me and Rosemary Hunter strongly can like criticize. We have a lot of doubts on that, but we definitely don't want to go like all the way further to the carceration road that American has been trying. So is there any way that probably in the future that we can better balance, carceration, and restorative justice to better, protect victims instead of, overly emphasizing on the rehabilitation of the abusers or perpetrators of child abuse?
I just want to say that I feel like this might be where CSAM and domestic abuse diverge, because for domestic abuse, a lot of people just want their abusers to move out, leave them alone, and stop it, which usually doesn't work because they just find another person to abuse, even if they do. But they just, a lot of people don't want to criminalize their partner or their child's father or mother because they don't feel like that's beneficial to the family as a whole. But I think for me that with child sexual abuse, it's different. So.
That maybe helps me segue into what I wanted to say earlier, that the scale of this thing is so huge.
Mm-hmm.
Yes, we don't have enough police resources, but the scale of child sexual abuse online is growing every single year. And we've been talking in the 5 years that we've been chatting about CSAR, every year, grooming, the amounts of children who are groomed double. And I think at this point, we're at 1 in 4 children who say that they've been groomed before online, or that they've experienced some kind of sexual unpleasant activities or sexual abuse or sexual extortion or any kind of activity online before they're 18 years old. 1 in 4, that's a lot of children, but that's normal, because otherwise where would these figures come from? Which means we need to deploy any means we can, that we legally can without killing our democracies. We really need to deploy everything. It's not about, let's just teach children some awareness, because they're up against criminal networks who are trying to groom them. Mm-hmm. So teaching children some awareness is really not going to help. Mm-hmm. We really need to do everything that we can. We need to use AI insofar that we can. We need to train police. We need to invest in this. But we also need to start thinking about how come is this system and how come is technology really facilitating it so much? And that's because it's not designed. It's enabling. It enables the slippery slope of people who get addicted to porn and who want bigger and bigger hits. So we need to target every single one of these things and really think about system design, because the system right now is designed to make it worse, not better. I think that's really...
I would also just like to add, specifically around incarceration, I appreciate what you're saying about not adopting an American model. I mean, they are stringent on these things. Around CSAM, I'm specifically talking about CSAM or TAXA. However, in the UK, we don't have an incarceration model. It's not the norm for this, for CSAM, certainly. For instance, I have case studies documenting fraud offences, which should be punished, right? You're breaking the law, but that's a non-violent offence. And we are putting those kind of offenders in prison, occupying prison space, taking resources away, and we are not putting CSAM offenders in prison routinely. So for me, there's a disconnect there, and we actually need better balance around that incarceration model. I'm not saying we go as far as America, but we have to start doing something different, because what we're doing is not working. My personal view around, this is not me speaking for MCF, but personally around restorative justice, I think it has value in lots of settings. I think it has very little to contribute when it comes to child sexual abuse offences. I would be extremely concerned around that because of offender motivations and the ability to groom even in those processes.
Okay, that's great. I think we'll end there. Can I thank the panel for coming along today, and thank everybody for attending. Thanks.